Since the Trust Act and the Trust Business Act became effective in Japan in 1922, trusts have evolved primarily as corporate trusts, in which trust companies serve as trustees. After the war, trust companies turned themselves into trust banks, offering both banking and trust services. That's why commercial trusts have long remained the mainstream of trusts in Japan, fulfilling corporate needs to raise and manage funds in the financial market. In an increasingly aging Japanese society, the accumulation of personal wealth by elderly people has underscored the pressing need for them to manage their properties safely and leave them securely to their family members. In this social trend, trusts are expected to play a larger role in civil application, namely the management, disposal, and inheritance of properties owned by elderly people. The 2006 amendment of the Trust Act has paved the way for new types of civil trusts, such as will substitute trusts and trusts with designated successor beneficiaries. In this session, I'll talk about these two types of trusts. Let me begin with a will substitute trust. As the name implies, a will substitute trust works as a substitute for a will. It's an arrangement under which a property owner acts as a settlor and puts their specified property into a trust. They designate their children or spouse as beneficiaries entitled to receive distribution from the property upon their death. This trust enables a property owner to dictate at their discretion how their property is to be distributed or disposed of after their death. The person who is designated to become a beneficiary upon the death of a settlor is called a post-mortem beneficiary. A will substitute trust allows a settlor, while they are alive, to dictate how their property is to be distributed to heirs or other specified parties. In this regard, it's similar in nature to a will or a donation in prospect of death, which is an arrangement for activating the donation of a donor's specified property to someone upon their death. A will substitute trust has an advantage over a will because it offers a greater chance for a settlor to distribute or dispose of their property exactly as they wish. Suppose a person leaves someone a specified property in their will. If that someone is one of the heirs to the estate, they're obligated to participate in a conference on the division of inherited property with other heirs when the property owner passes away. The division of the estate resulting from the conference may be different from what the owner originally intended in their will. A conference on the division of inherited property is part of a legitimate inheritance procedure. When there's a conflict, the outcome of the conference takes precedence over a will. In a will substitute trust, the entrusted property is not subject to a conference on the division of inherited property. The trustee that manages the property transfers it directly to a designated post-mortem beneficiary upon the death of a settlor. This means a will substitute trust allows a settlor to distribute or pass on their property exactly as they wish. There's two types of will substitute trusts. One has a provision that a settlor is to designate themselves as a beneficiary while they're alive, and that a person designated as the one who is to be a beneficiary is to acquire a beneficial interest upon the death of the settlor. The other type has a provision that a beneficiary designated by a trust agreement is to receive distribution involving the trust property upon the death of the settlor or thereafter. Unless otherwise stated in a trust agreement, a settlor may change designated post-mortem beneficiaries at any time. This is similar to the arrangement that allows a property owner to revise their will at any time, or that allows a donor to cancel a donation in prospect of death at any time. In a will substitute trust, in which a designated beneficiary may receive distribution involving the trust property only upon the death of the settlor or thereafter, the beneficiary doesn't have a beneficiary right until after the settlor passes away, unless otherwise stated in a trust agreement. Alternatively, the settlor exercises a beneficiary right while they're alive, including oversight of the trustee. In addition, a settlor may terminate a will substitute trust as they wish or change its terms with the consent of a trustee. A will substitute trust enables a property owner to dictate, while they're still fit and competent to make rational decisions, how their property is to be distributed and to whom when they die, and thus frees the owner from worrying about the impairment of judgment with age. For instance, using this trust, a small business owner can leave a designated successor the business assets and stocks to have them take over the business. A property owner leaves a residential property and living expenses to their child with disabilities. However, in cases where there are several heirs to the estate, the terms of a will substitute trust must not infringe on other heirs' rights to legally secured portions of the estate. Otherwise, a post-mortem beneficiary designated by the settlor will be served with a distributive, share-reducing request by disgruntled heirs. An individual or corporate entity may serve as a trustee under a will substitute trust. Trust banks offer packaged will substitute trust products. In most cases, banks agree to manage only monetary properties of settlers, out of which they pay lump sum death benefits and fixed installment of benefits at regular intervals to bereaved family members upon the death of settlers. In cases where trust property comprises securities or real estate, other forms of civil trusts are chosen. Let's move on to a trust with designated successor beneficiaries. It's an arrangement under which a beneficiary passes away, their beneficial interest becomes void, and a person designated as a successor beneficiary by the settlor acquires a new beneficial interest. For instance, a settlor designates themselves as a first beneficiary while they're alive, and when they pass away, their spouse becomes a second beneficiary. Upon the death of the spouse, the settlor's child becomes a third beneficiary. It's also called a bequest-type trust with designated successor beneficiaries, as several persons designated as beneficiaries acquire a beneficial interest successively as each of them passes away. In this trust, each of the beneficiaries does not take over a beneficial interest from their predecessor when they pass away, but acquires a new beneficial interest directly from the settlor. This trust runs for several generations of beneficiaries. When a living beneficiary acquires a beneficial interest under the terms of the trust after 30 years have passed since the establishment of the trust is terminated when that beneficiary passes away. Inheritance by will does not allow a testator to name a second successor to their estate. In a trust with designated successor beneficiaries, however, an owner of a family business can designate several persons as consecutive successors to their business, and a property owner can ensure the livelihood of their family members and their children for generations. A civil trust is an arrangement under which an individual acts as a trustee who handles the management, disposal, or inheritance of an elderly person's property. It's also called a family trust, as the settlor's family member is often chosen as a trustee. Civil trusts, however, has been rarely used, although they were legitimized by the Trust Act effective in 1922. In recent years, civil trusts have attracted the attention of lawyers and judicial scriveners as a means of managing properties of the elderly. Since their procedures and benefits became widely known, civil trusts have been gaining popularity. Civil trusts and commercial trusts, in which trust banks serve as trustees, are both subject to the Trust Act and are similar in terms of how they work and their legal nature. In civil trusts, however, family members serve as trustees not for profit and therefore are not subject to the Trust Business Act or the Act on Engagement in Trust Business by Financial Institutions, both of which govern trust companies and banks that act as trustees for profit. Civil trusts are not the only means of managing the properties of elderly people with impaired judgment. Adult guardianship and voluntary guardianship are family court-involved public means of property management. In an adult guardianship, a guardian is appointed by a family court, and a family member may not always be appointed as one. In a civil trust, a settlor may specify exactly which part of their property is to be managed under a trust. In adult guardianship, however, all properties owned by and all transactions conducted by an elderly ward are controlled by a guardian. In addition, in adult guardianship, the disposal of significant property such as substantial savings, securities, and residential real estate requires court instruction to proceed. Voluntary guardianship becomes effective only after a voluntary guardianship agreement is registered and when a voluntary guardian supervisor is appointed by the court as a ward's judgment has deteriorated. A voluntary guardian has no right to rescind to a ward's conduct. It's true that adult guardianship has a robust built-in safeguard for the protection of an elderly ward's rights, including the court's oversight of a guardian. But the disposal of their property needs to go through many layers of procedural requirements. That's why some people prefer civil trusts to guardianship, as they're easier to set up and provide greater flexibility. To summarize, advantages of a civil trust are: number 1, a settlor's family member may be named as a trustee. Number 2, a settlor may specify which part of their property is to be managed or disposed of under a trust. And number 3, unlike adult guardianship, a civil trust remains effective even after an elderly settlor passes away, and the trustee continues to manage and dispose of the deceased property. There are 3 basic applications of civil trust for the elderly. The first application is to provide livelihood support to an elderly settlor. When you get old, your judgment may be deteriorated to the extent that you may not be able to draw money from your bank account, sell or buy real estate properties or securities, or conduct routine transactions. A civil trust intended for an elderly settlor mitigates their risk of diminishing judgment with age. The trust allows them, while they're still fit and competent to make rational decisions, to designate themselves as a beneficiary and appoint a family member or the like as a trustee responsible for managing and disposing of the property of their choice under a trust. The trustee manages and disposes of the property on behalf of the elderly settlor, who is also a beneficiary, and supports their livelihood by providing living expenses out of the trust property. In a civil trust, a settlor may draw up a trust agreement exactly in a manner that reflects their will. For instance, the agreement specifies down to the smallest detail how the settlor's property is to be managed or disposed of, and what kind of livelihood support is to be provided to the settlor. The second application is to facilitate inheritance of a settlor's property. A will substitute trust enables the settlor to entrust their specified property to a trustee and designate a specified person as a post-mortem beneficiary entitled to inherit the specified property. For instance, a small business owner allows a designated successor to take over the business assets and stocks after their death. A property owner leaves a larger portion of a residential property and living expenses to their family member with disabilities. In these cases, a settlor must ensure that the trust will not infringe on other heirs' rights to their legally secured portions of the estate. The third application is to have someone else conduct business, such as real estate leasing and securities investment, on behalf of a settlor. For instance, an elderly settlor engaged in an apartment leasing business designates a family member as a trustee who manages the apartment and lease contracts with tenants on behalf of the settlor. When the settlor loses their capacity for sound judgment or passes away after the trust is set up, the trust remains in effect and the trustee can continue to manage the business. When a settlor actively invests their property, a civil trust, not adult guardianship, is a viable option to choose. In civil trusts, any individuals may serve as trustees. They don't need to have any official qualifications to do so. Just like commercial trusts, civil trusts are subject to the Trust Act. A trustee is obligated to administer trust affairs with due care of a prudent manager, faithfully on behalf of a beneficiary, and by separating the trust property from other properties. If a trustee fails to fulfill the terms of a trust agreement, they are liable to compensate for losses or restore the property to its original state. Civil trusts are based on relationships of trust among family members. However, a beneficiary can enjoy legal protection under the Trust Act only when a signed trust agreement meets all legal requirements and the trustee administers trust affairs in accordance with the provisions of the Trust Act. Therefore, it's recommended that all parties involved in a civil trust consult a lawyer, a judicial scrivener, a trust bank, or other experts to learn how a trust works and what rights and obligations they have before proceeding with the trust. Some trust banks offer customers interested in setting up a civil trust special services such as referral to experts and saving accounts for trustees to manage the entrusted funds separately. These saving accounts are called trust accounts and are used to separately manage funds in a trust property. In this increasingly aging society, civil trusts are expected to be more widely used going forward. Unlike adult guardianship, which is supervised by the court, civil trusts are based on relationships of trust among family members. All parties involved in civil trusts are required to adhere to all the rules established by the Trust Act to ensure their sound development and application. Legal experts in trust banks are encouraged to play a larger role in assisting those who serve as settlers, trustees, and beneficiaries under civil trusts in gaining better understanding of how trusts work and conducting trust affairs in compliance with the Trust Act. This concludes my presentation.